Hello, my name is Steve Cortes at the Cortes Law Firm, and this is the fourth of 6 educational videos in a series that we are doing on estate planning. If you missed the first 3 videos, then you can use the links below to watch them. And if you have any questions along the way, then please don't hesitate to give us a call. Now, today our discussion is about the essential legal documents you need for incapacity planning. Now, my clients are usually surprised with the amount of time I spend discussing incapacity planning. Comprehensive estate planning is more than about your legacy after death, avoiding probate, and saving on taxes. It must also be about having a plan to manage your affairs if you become incapacitated during your lifetime. Without comprehensive incapacity planning, a judge might appoint a guardian to take control of your assets and make healthcare decisions for you. This guardian will make all personal and medical decisions on your behalf as part of a court-ordered supervised guardianship. Until you regain capacity or die, you and your loved ones will be faced with an expensive and time-consuming guardianship proceeding. What is worse is that a judge might appoint, a total stranger as your guardian. If you are legally incapacitated, you are legally unable to make financial decisions. But bills still need to get paid. So you must have these 2 essential legal documents for managing finances in place prior to becoming incapacitated. The first is a financial power of attorney. This gives someone that you trust the authority to pay your bills and manage all other financial matters. Second, you need a revocable living trust. This document has 3 parties to it. The first is the person who creates it, called the grantor. The person who manages the assets that are in the trust, called the trustee, and the person who benefits from the assets in the trust, called the beneficiary. In the typical situation, you will be the trustor, the trustee, and the beneficiary of your own revocable living trust. But if you ever become incapacitated, then your designated successor trustee will step in to manage the trust assets for your benefit. Now that covers finances, but what about healthcare? Healthcare decisions must still be made. So if you become legally incapacitated, you won't be able to make healthcare decisions. And because of patient privacy laws like HIPAA, your loved ones may be denied access to medical information during a crisis and end up in court fighting over what medical treatment you should or should not receive. So you should have these 3 essential legal documents for making healthcare decisions in place prior to becoming incapacitated. The first is a medical power of attorney. This legal document gives someone that you trust the authority to make healthcare decisions if you become incapacitated. The second is a living will. This legal document gives someone you trust the authority to make life-sustaining or life-ending decisions if you become incapacitated. The third is a HIPAA authorization. This legal document gives your doctor authority to disclose medical information to someone that you trust. Now, as you can imagine, all 3 of these healthcare documents work together to create your incapacity plan. Once you get all of these legal documents for finances and health in place, you can't simply stick them in a drawer and forget about them. Incapacity planning is ongoing and must be reviewed and updated every 2 to 3 years or when your circumstances change. If you keep your incapacity plan up to date, you should expect it to work the way you want it to. Well, that's all we have for today. I hope you found this useful, and if you have any questions, please don't hesitate to call me. Thanks, and stay tuned for our next video on why my probate is taking so long. See you next time.